we can agree between all of us that I read out the resolution. Leave off all the claims, all the arguments, because the resolution will also bring out the claims and the submissions of learned counsel. Is that all right with us?
Yes, my lord.
Very well. So when the resolution is quite lengthy. Okay. Okay, that's it. Well, I will start with the resolution. Having gone through the claimant's claim, the evidence led in support, the defendant's defense, and the final written submissions of counsel on both sides, this court, while adopting all the issues formulated by counsel, has distilled 2 issues for determination. And these 2 issues are: A, whether, given the circumstances, the document tendered and admitted in evidence as Exhibit C8 is inadmissible at law. B, whether the claimant has proved his case to be entitled to the reliefs sought. On issue number 1, the document marked as Exhibit C8 formed part of the introductory part of the defendant's final address, to which the defendant's counsel ventilated their objection to the admissibility of the said document, which is titled Account Statement Summary from Stanbic IBTC. To the defendants, the document ought not to be admitted, as it violates the provisions of Section 89 and 90 of the Evidence Act. On the part of the claimant, learned counsel to the claimant argued, amongst other things, that the objection of the defendant to the admissibility of Exhibit C8 is coming at the inappropriate time. That such objection ought to have come at the outset. The defendant was to object when he had the chance to do so, as provided in Order 15, Rule 3 and 4 of the Civil Procedure Rules of this Court, 2017. I would like to reproduce the provisions hereunder, and it provides thoughts. I quote: where a defendant's respondent is served with a schedule of documents or any record by an electronic device to be relied on at the trial by the claimant, in compliance with Order 3 Rules 9 and 10 of these rules, the defendant or defendants shall file and serve along with the defense a schedule that indicates: 1, the document or documents or any recording by an electronic device, the admissibility of which the defendant shall not be objecting to at the trial; and 2, the document or documents or any recordings by an electronic device which the defendant shall be objecting to at the trial. Section B4 says that any document or recording by an electronic device contained in the schedule which is not objected to by the defendant shall be deemed admitted, except the court otherwise directs. And C of that rule says, provided at all times that a party that has signified an intention to object to the admissibility of a document or documents or any recording by an electronic device sought to be by the other party have filed separately a short but succinct written address stating the ground or grounds of objection and the legal argument and authority for same. Provided also that a party to whose documents and or any recordings by an electronic device an objection has been raised, upon being served with the notice of objection together with the written argument in support of the same, shall accompany such parties' reply process or processes which shall be on point of law, with a written address in response to the objector's statement within 14 days of the service of the objector's process or processes. Provided further that at the commencement of the trial, the court may take and dispose of all arguments on the admissibility and non-admissibility of the documents or any recording by electronic device of all the parties. He says nothing in the foregoing shall preclude the court from taking the arguments on admissibility and evidential value of documents and exhibit alongside arguments as to the substantive suit at the close of evidence at the stage of final addresses. Now, from the foregoing and from the underlined, the court underlined E for emphasis. It is glaring that even though the beginning of the rules laid emphasis on objection to the validity of documents to be brought at the early stage of the suit, the end part of those same rules provided that nothing in the aforementioned rules shall preclude the court from taking arguments on admissibility and evidential value of documents alongside arguments taken in the substantive suit at the close of evidence at the stage of final written addresses. In this vein, it is not out of place for this honorable court to entertain the objection of the defendant's hearing, which was brought at the final address stage of the suit, and the court so holds. I would like to add that the rules of court are a helpful guide to the court, and the court cannot be seen as being slavish to its own rules, which are her helpmates. See Anyaso versus Anyaso, reported in 1998, 9 Nigeria Weekly Law Report, part 564, page 150. The court held in that suit that a rule of court should be a helpful handmaid and not a tyrannical and uncompromising master. It is undesirable to give effect to rules which permit one party to score cheap technical victory at the expense of hearing on the merits. See also the case of Atiku Abubakar versus Umaru Musa Yaradua, reported in 2008, 4 Nigeria Weekly Law Reports, part 1078, page 465 at 511, where the court held that rules of court are meant to be obeyed. The obedience should not be slavish to the point that justice in the case is destroyed or thrown overboard, unquote. In this light, the position of the claimant would have been more appropriate if there was a pre-trial conference to which consideration was given for documents that will be tendered and admitted without objection, as well as documents that will be tendered and admitted with objection before the beginning of the proper trial. Furthermore, whenever a defendant joins issues with the claimant through his statement of defense, to which he vehemently denies the claim of the claimant and put the claimant to the strictest proof of his claim, there is always the presumption that such a defendant will extend his vehement denial to the objection of the documents that the claimant will seek to tender in support of his claim. So in all, nothing stops the defendants from bringing the objections at this stage of final written addresses. The objection of the defendants to Exhibit C8 is predicated on Section 89, sub F, and 91E of the Evidence Act of 2011. For the purposes of clarity, I would like to produce sections 89F to H and 91E of the Evidence Act below. Section 89 says, secondary evidence may be given for the existence, conditions, or contents of a document when, Section F says, the original is a document of which a certified copy is permitted by the Act or any other law enforced in Nigeria to be given in evidence. Then sub G says, the original consists of numerous accounts and other documents which cannot conveniently be examined in court, and the fact to be proved is a general result of the whole collection. Or H says the document is an entry in a banker's book. Then section 90 sub 1 says the secondary evidence admissible in respect of the original document referred to in the several paragraphs in section 89 are as follows. E, in paragraph H, the copies cannot be received as evidence unless it is first proved that the book in which the entry copies were made was at the time of making one of the ordinary books of the bank. 2, the entry was made in the usual and ordinary course of business. 3, the book is in control and custody of the bank, which proof may be given orally or by affidavit by an officer of the bank. And 4, the copy has been examined with the original and it is correct, which proof must be given by some person who has examined the copy with the original copy and may be given orally or by affidavit. On the part of the claimant's counsel argued that sections 89 and 90 of the Evidence Act do not apply in this circumstance. Rather, it is section 84 of the Evidence Act which touches on computer-generated documents that applies. I quite agree with the claimant in that in this circumstance, it is section 84 of the Evidence Act 2011 on computer-generated documents that applies. This is so because on a careful look at Exhibit C8, it is obvious that it is more of a document generated from a computer than a document copied from a book or banker's book. The question, therefore, is, do banks still keep information? Do banks still keep information in banker's books? We live in an era where data is kept in a database or server, and with the snap of the finger, sending a query to the database or server, information is pulled out on the computer screen and printed out using a printing device. In all fairness to the defendants, there is nothing like book or books these days in the operation of a bank. From opening your account to withdrawing money or printing a bank statement, the information is fed into a computer and pulled out of the computer. In this light, the claimant is not wrong to, while seeking protection of the court in section 12 of the National Industrial Court Act, to depart from section 89 and 90 of the Evidence Act 2011 to do justice in this case. He is also relying on the provisions of section 84 of the Evidence Act 2011 as a proper section to govern this kind of transaction. In the light of what has been said above, the court will not discountenance a bank statement which has the imprimatur stamp and signature of the issuing bank officer, and it was issued for the benefit of the person who seeks to tender it. After complying with section 84 of the Evidence Act 2011 on computer-generated documents, for whatever it is worth, the provisions of the Evidence Act on banker's book no longer aligns with the reality of our times. As such, it is becoming quite archaic because the reality of our times is that banks now deploy the use of technology in rendering their services, not books or bankers' books. Enforcing this law is like taking us back to the era where everything from opening a bank account to withdrawal, etc., were recorded on a book. I would rather a bank statement is now treated as a computer-generated document than a document sourced from the bank books that do not exist. And I strongly believe that such a legal advocacy caused an amendment of the Evidence Act to accommodate computer-generated documents. One day, legal advocacy will also cause an amendment in section 89 and 90 of the Evidence Act to meet the reality of our times as far as bank statement is concerned. Even though I quite agree with the Claimant's Counsel's submission, that it is the provision of the Evidence Act on computer-generated document that applies in this case. There is a little thing about SBC 8 that makes me uncomfortable. And whenever I look at it, it reminds me of the Holy Book when it says, "Beware of the little foxes that spoil the vine." Could it be that there is a little fox that spoils the vine of computer-generated documents? In paragraph 15 of the Claimant amended statement of facts, the claimant aveils thus at paragraph 15. The claimant says that he was surprised to know at the time he voluntarily resigned from the employment of the first defendant that the first defendant only remitted his pension contributions for the month of October 2011 and for the month of February, respectively, in 2013, out of 5 solid years of his employment with the first defendant, despite that the first defendant had deducted the said pension contributions accordingly from his salary for each month of the 5 years, but did not remit them. The claimant shall found and rely on account statement summary of his pension fund administrators at the trial of the suit. Now, to go back to the little fox thing, the document which the claimant availed to found and rely on is what is admitted before this honorable court as Exhibit C8. Supposedly, that same document is from a financial institution. Surprisingly, the same document lacks authenticity and it makes no pretense about it. As stated earlier, the court will not discountenance a bank statement which has the imprimatur and signature of the issuing bank officer, and it was issued for the benefit of the person who seeks to tender it after complying with Section 84 of the Evidence Act 2011. However, what will become of the court if it doesn't discountenance a document supposedly issued by a financial institution, yet the document does not have the heading of the financial institution, no stamp or signature of the issuing officer or the financial institution? These are the little foxes that spoil the vine of Exhibit C8. And in the face of all these anomalies, which underscore lack of authenticity, there are plethora of judicial authorities on the point that an unsigned document is a worthless document. Consequently, this court is constrained to hold that Exhibit C8 is a worthless document. Accordingly, shall be expunged from the records of the court, and I so hold. That said, the court shall proceed to determine issue number 2 distilled by this honorable court. The court will address other objections while determining issue number 2. And that issue says whether the claimant has proved his case to be entitled to the relief sought. Generally, civil cases are decided on the preponderance of evidence. The court puts the evidence of both parties on an imaginary scale, and judgment is entered in favor of the party whose evidence preponderates. His Lordship, Fatai Williams, JSC, as he then was, put it succinctly in the case of Mogaji versus Odofin, reported in 1978, citation supplied. The judge should first of all put the totality of the testimony adduced by both parties on an imaginary scale. He will put the evidence adduced by the plaintiff on one side and the scale and that of the defendant on the other side and weigh them together. He will then see which is heavier, not by the number of witnesses called by each party, but the quality or probative value of the testimony of these witnesses. In determining which is heavier, the judge will naturally have regard to whether the evidence is admissible, relevant, credible, conclusive, and more probable than that given by the other party. In the case hearing, the defendants filed a statement of defense, but did not tender any document or call any witness to give oral evidence. By the way, it was the defendants who elected not to call witnesses or tender any documents in this case. According to the claimant, failure to defend the case by oral and documentary evidence is tantamount to abandonment of the defense of the claimant and an admittance without more of the case of the claimant by the defendant. Be it as it may, the trial law is that pleadings cannot constitute evidence. Therefore, a party who pleads should lead evidence in support of his pleadings. See the case of IBWA Limited versus Emmanuel Nigeria Limited. It was reported in 2001, citation supplied, where the Supreme Court held, and I quote, "It is the law that pleadings cannot constitute and do not tantamount to evidence, and a defendant who does not give evidence in support of his pleadings or in challenge of the evidence of the plaintiff is deemed to have accepted the facts in dispute as adduced in the evidence by the plaintiff, notwithstanding the general traverse in his pleading." Does it mean that the claimant will be automatically entitled to judgment when the defendant fails to lead evidence in support of his case? In the case of Mr. Lawrence Azenabo versus Bayero University, Kano, it was reported in 2011. The position of the court was that such a claimant is not entitled to automatic judgment, but is required to prove his case on a minimal standard. That was also the decision of the Supreme Court in Ogunyade versus Oshun Keye, reported in 2007. Citation supplied. Also, the trial law is that the claimant succeeds on the strength of his own case and not on the weakness of the defendant's defense. In this vein, as well as in the case hearing, it is immaterial if the defendant failed to call evidence in proof of their case or have a weak case. What is material is that the claimant has sued the defendants and by dint of fate, the defendant did not call evidence in support of their case. And this has given the lock to the claimant to prove their case on the basis of minimal proof and no more. In the light of the above, the court will proceed to look at the claims of the claimant and see how he has proved his case minimally. In reliefs 1 to 4 of the claimant is asking for money claimed to be his pension remittance and money that constitutes 2% interest as penalty against the first defendant for non-remittance of his pension funds to claimant's pension administrators as at when due. I notice that there is an error in the amount claimed as pension funds. In relief number 1, the amount is stated to be 3,451,888 naira, while in relief number 2 and 4, the amount was stated as 3,541,888 naira. Whether it is a slip or deliberate, it would have been better if the claimant acknowledges or prays the court to adopt one and leave out the other. In the interim, the court, in the interest of justice, will take it as a slip, except it finds reason to believe it was deliberate. In paragraph 16, 17, and 18 of the claimant's amended statement of facts, the claimant averred thus, and I quote him, that the first defendant had, after deductions as shown in his various pay slips, only remitted a disappointing total of 337,112 naira 12 kobo out of his total pension contribution of 541,888 naira due to the claimant while in the employment of the defendant, etc. Then, and on paragraph 17, the claimant says that the defendant owes him the sum of 3,541,888 naira, which is derived from subtracting 337 naira, 337,112 naira 12 kobo, being the total pension contributions deducted from the claimant, but were never remitted by the first defendant. Then paragraph 18, the claimant says that its particulars of pension contributions for the 5 years of his employment with the defendant, which have been deducted but were not remitted by the first defendant, are as follows. D. October to December 2010 at 28,125 naira times 2, which equals 56,250. Then times 3 months, which now equals 168,750 naira. Then January to December 2011 at 28,125 naira times 2 times 12 months, which equals 675,000. January to December 2012 at 28,125 naira times 2 times 12 months, which equals 675,000. January to June 2013 at 28,125 times 2 times 6 months, which equals 337,500. July to December 2013 at 34,875 naira times 2 times 6 months, which equals 418,500. Then January to December 2014 at 34,875 naira times 2 times 6 months, or 12 months, that is in doubt, which equals 837,000. And lastly, January to November 2015 at 34,805 naira times 2 times 11 months, which equals 707,250 naira. Then at page 13 of the claimant's final written address, claimant's counsel submitted that sections 11 sub 3 sub A of the Pension Reform Act provides that the employer shall deduct the monthly contribution of the employee at source not later than 7 days from the day the employee is paid the salary, and remits the amount comprising the employee and employer's contribution to the pension fund custodian. The failure to do so attracts a penalty. On the part of the defendants, in pages 12, 13, 14, 15, and 16 of the defendant's final written address, the defendant's counsel submitted that the claimant was unable to prove his entitlement to money claimed as pension contribution. He went on to highlight the inconsistencies in the amount stated as 3,451,888 naira and 3,541,888 naira. The inaccurate calculation done by the claimant and the not so clear percentage the claimant used in arriving at the amount claimed, that under cross-examination, the claimant claimed he used 10% in the contribution quota of the first defendant and 7% in the contribution quota of the claimant as an employee. Thus, according to the defendant's counsel, contradicts the employment letter of the claimant, that is Exhibit C1, which states that the pension contribution will be 7.5 of the claimant's basic salary, housing and transport allowance, and in addition, 7.5 from the first defendant based on the aforementioned. That for the Pension Reform Act, it came into being in 2014, which effective date of 1st July 2014. Section 4.1 of the Pension Relief Act 2014 provides that the pension contribution be 10% from the employer and 8% from the employee. The Act also provides that the rates might be reviewed upward by the agreement of parties, and the Pension Commission will be notified of the upward review. In all this, the Defendants Council's position is that the claim of the claimant on this head must fail, since he was unable to demonstrate how he arrived at his figures or the premise of his calculation on the contract of employment and applicable statutes. I must say that the claimant did a poor job on the figures and numbers. I have earlier noted the slip or error in the stated amount of 3,451,888 as against 3,541,888 naira. I also noticed that in claimant's relief, in the body of his statement of facts, particularly at paragraphs E, F of his particulars of claim, his calculation was January to December 2014 at 34,875 naira times 2 times 6 months, which gave him 837,000 naira. Now, I don't know where January to December ended up being 6 months rather than 12 months. Also, where does 34,875 naira times 2 times 6 equal 837,000 naira rather than 418,500? And just when I thought we were done with these inconsistencies, the defendants are here inundating us with the inconsistencies from their own discovery. What is more, perhaps the claimant has a phobia for maths or numbers, and this may have led to the inconsistencies we have seen here in numbers and percentages. Be that as it may, the court will, while acting within the documents tendered before it and with the provisions of the law, do justice to these inconsistencies in numbers and percentages. Acting on evidence and documents before the court and acting within the ambit of the law is not cloistered. It's not cloistered justice. It is acting outside documents evidence before the court that is cloistered justice. The only inconvenience the court will have to grapple with is that the claimant has succeeded in making the court a mathematician in the game of numbers, just as the Supreme Court was saddled with the game of numbers in the case of Hope Uzodimma and another, versus Ihedio and others, which was reported in 2020, LCN/4905. It's a Supreme Court case delivered on the 14th day of January 2020 with suit number AC/1462/2019. Before the emergence of the Instant Pension Reform Act in 2014, which was signed into law by the President Jonathan-led administration, there was a Pension Act that made provision for the equal contribution of 7.5 from both employer and employee. It is not out of place for the claimant's letter of employment to read pension. The pension provision will be in line with statutory requirements. Your contribution will be 7.5 of your basic housing and transport. In addition, Arik Air Limited shall also contribute 7.5 basic on the above salary. Now, with the above, the first defendant was not acting as a Father Christmas, but was merely obeying the extinct act on pension contributions. From Exhibit C1, the claimant's letter of employment. The claimant's employment took effect from 27 September 2010. By this the claimant became due for his first salary and first pension contribution by the end of October 2010. Therefore, the claimant's pension contribution can be calculated using dual contributions of 7.5 of the claimant's basic salary, transport and housing allowance from October 2010 to June 2010, based on the extinct Pension Act. Thereafter, from July 2014 to November 2015, when the claimant ceased to be an employee of the first defendant, his pension contribution shall be calculated based on 10% contribution from his employer.
Madam Susan, we are enjoying your food though.
$465,000 is 37,200. Moving further, 46,500 plus 37,200. That is the employer's 10% and employees 8% equals 83,700. Therefore, between the period of July 2014 to November 2015, which is a period of 16 months, the claimant pension contribution is 83,700 times 16, which amounts to 1,339,200. In the light of the above, what the defendant owes the claimant for the period of July 2014 to November 2015 is 1,339,200 naira only. From all the total sums arrived above, the total sum owed the claimant by the defendant as unremitted pension contribution is 2,475,000. 2 million, no, 2,475,000 plus 488,250, 1,339,200 equals 4,303,450. In this vein, the total sum yet to be remitted by the first defendant to the claimant pension administrator from the period of 5 years that the claimant worked with them is 4,302,459. For the avoidance of doubt, this court, as a court of first instance, is vested with the power to scrutinize and evaluate the evidence before it. In this vein, it must be noted that the figure the court arrived at above is based on careful scrutiny and evaluation of the evidence before it, and on the application of the Pension Act, which is the law that governs the nature of the transaction in question. On the issue of receivership on the assets of the first defendant, parties for me spent time arguing about the propriety of the second defendant being joined as a party in this suit, and whose responsibility it is to pay the claimant arising from the fact that the claimant was not employed by the second defendant. On this, I must say that if the second defendant is in receivership of the assets of the first defendant, or if the assets of the first defendant is being liquidated, the duties owed creditors and shareholders of the first defendant, and the way and manner creditors or shareholders are well spelled the relevant provisions of the Company and Allied Matters Act. In this vein, it is of no moment whether or not the second defendant is the employer of the claimant or is not the one who owes the claimant. Furthermore, as to whether the second defendant is a proper party in this suit, the court wishes to state that for all intents and purposes, the second defendant is a proper party in this suit. For, if not for anything, it is a party by implication, and also a party for the purpose of enforcing the judgment of this court, given the facts of this case. The law is right that a proper party is a person made a party to an action because of his involvement leading to the cause of action, and in this case, a proper party, even though the court can decide the issues in his absence. He becomes a party not because he's a necessary party, but because of the role he played in the action giving rise to the suit. The second defendant, from the role he played in the facts already before this court, is a proper party, and I so. On reliefs 3 and 4, this court wishes to state that these reliefs are bad because from the provisions of the penalty expected to be paid for failure to remit the pension contribution within the specified period is money paid to the commission and not an individual. Also, the penalty of 2% in PENCOM Act criminalizes non-remittance. As such money cannot be paid to the claimant, but the state, that is the government. On relief number 5 and 6, there is no evidence before me that the claimant was paid his salary and other ancillary allowances for the month of November 2015, even though he worked for this period. In this vein, this relief is bound to succeed. On relief number 7, which is termed 1 month salary in lieu of notice, is bound to fail because the contract of employment provides that either of the party can bring the employment to an end by giving notice or forfeiting 1 month salary in lieu of notice. In this case, it was the claimant that brought the employment to the end by giving 1 month's notice to the defendant. He cannot therefore turn around and ask for 1 month's salary in lieu of notice. Doing this is tantamount to beating somebody and yet crying the tears that are meant for the person beaten. This is alien to our labor law jurisprudence. Relief number 8, which is an unpaid leave allowance from 2010 to 2015 is bound to fail also because from the evidence before the courts, the employment contract specifically states that during the leave, the claimant shall only be entitled to basic salary. No leave allowance was mentioned. The tried law is that parties are bound by the contract freely entered by them. In this light, the claimant cannot seek a remedy or right outside the terms of his contract, and I so hold. Leave number 9 is bound to fail because the claimant has not shown any scintilla of evidence to substantiate how he is entitled to gratuity. Now, from all that have been said above, the case of the claimant succeeds as follows. Claim number 1 succeeds. Claim number 2 succeeds. Claim number 3 fails. Given the circumstances of this case, the penalty of 2% does not avail the claimant, but the authority, that is TENCOM. Then claim number 4 fails, arising from the failure of claim number 3 above. Claim number 5 succeeds, to the extent that there is no evidence before me to show that the claimant was paid his November 2015 salary, even though he worked for that period. Claim number 6 succeeds, to the extent that there is no evidence before me to show that the claimant was paid his allowances from November 2015, even though he worked for that period. Claim number 7 fails because it is alien and unknown to law. The employer does not pay the employee salary in lieu of notice when it was the employee that brought the employment to an end. Claim number 8 fails to the extent that it is stated in black and white in claimant's employment letter that during leave, claimant will only be entitled to his basic salary. No provision was made for leave allowance. Claim number 9 fails to the extent that the claimant did not tender any documents on his contract that makes provision for gratuity. In this light, pension is the only settlement, not gratuity and pension. Claim number 10 fails because, given the circumstances of this case, the court is not moved to grant any sum as pre or post judgment interest. Claim number 11 fails to the extent that the claimant cannot derive any benefit as general damages for giving his conduct. He secured a job with the first defendant's competitor, and he didn't disclose this until the first defendant found out and queried him on this. He who comes to equity should come with clean hands. Claim number 12 fails for, given the circumstances, the court is not moved to grant any sum as cost. For the avoidance of doubt, the declarations and orders of the court are as follows. 1, the court hereby declares that the first defendant's failure to immediately transfer or remit total, complete, absolute monthly pension contributions to the claimant for the entire period of his employment with the first defendant into his retirement savings account with his pension fund administrators being Stanbic pension managers to the tune of 4,302,450 naira is unlawful, illegal, and same is a clear breach of his contract of employment. 2, the court hereby makes an order directing and mandating the defendants to immediately transfer or remit the total, complete, and absolute monthly pension contributions of the claimant for the entire period of his employment with the first defendant to his retirement savings account with his pension fund administrator being the Stanbic pension for the entire period to the pension fund administrator 302,450. 3, the court hereby orders the defendants to pay to the claimant the sum of 155,000 naira being unpaid salary for the month of November 2015. And lastly, the court hereby orders the defendant to pay to the claimant the sum of 580,820 naira being unpaid total allowance for the month of November 2015. And that is the statement of the court. Then it's entered at
As a couple. My Lord, we thank you for the considered judgment.
Thank you.
And we are grateful for your judgment.
Okay. What is making this noise? From them. Okay. Okay. Next one. Okay. Next one. Appearances.
Yeah.
Yes.
Yeah.
Appearances.
Sorry, what matter did they call now? I couldn't hear.
149, 22. International master.
With greatest respect, my lord, I am okay. I appear for the claimant. Appear with me is O Oluwadare for the claimant.
Okay. Yes. Yes. Mr. Omorebe, are you there? Mr. Omorogbe. Is it? Okay. It's not. Mr. Okay.
Yes, my lord.
Yes, please, because there are so many matters that we are going to attend to today, and most of them are quite lengthy. So
Yes,
I don't know if you really mind if I read out the decision of the court, since you are
I'm
going
fine with it.
Yes.
That's fine by us, my lord.
Okay, very well. So the defendant is not represented. Okay. So having gone through the case of the claimant, its the positions and written address, as well as that of the defendants, this court has distilled the sole issue for determination, and that is to say, whether given the circumstances, the claimant is entitled to the relief sought. Before addressing the issue distilled above, the court would like to avert its mind to the preliminary objection of the defendant, dated 14 September 2022, to which the defendant prayed the court to decline jurisdiction in this suit, strike out or dismiss the suit, or order the claimant to file pleadings. The positions of the defendant is basically on the ground that this suit, instituted by way of originating summons, contains contentious and controversial facts which cannot be resolved without adducing evidence. In Order 3, Rule 3 of the National Industrial Court Civil Proceedings Rules 2017, it is provided that, and I quote, civil proceedings that may be commenced of originating summons, include matters relating principally to the interpretation of any constitution, enactment, agreement, or any other instrument relating to employment, labor, and industrial relations, in respect of which the court has jurisdiction by virtue of the provisions of section 254 sub C of the Constitution of the Federal Republic of Nigeria, 1999, or by any act or law in force in Nigeria. So from the provisions above, it is clear that civil proceedings in this court can be commenced by originating summons or any matter on which interpretation of any agreement, interpretation of instruments, circular, letter or documents relating to employment, labor, or industrial relations. Furthermore, in originating summons proceedings, the court does not expect that the respondent will not counter the originating summons by filing a counter affidavit. However, what the court looks at is whether from the face of the originating summons and the counter, there is a serious dispute of the facts to which the court cannot properly resolve except by way of calling witnesses, thereby necessitating an order for the filing and exchange of pleadings. The law is strict that the use of originating summons is resorted to when the rights claimed or relief sought are predicated on the interpretation or construction of documents, agreements, contracts, statutes, and other instruments, or where material facts are not in dispute or not likely to be in serious dispute between the parties. See the case of Kanyip versus House of Assembly, Lagos State, voted in 2002. Citation supplied. In the case hearing, what the claimant is calling for interpretation on is employment document that binds it with the defendant. In this light, it is a matter that can be properly brought by way of originating summons, and I so hold. Consequently, the preliminary objection of the defendant dated 14 September failed and sent here by the case. Now, moving on to address the issue distilled above. The case of the claimant hearing is on the failure of the defendant to give a month's notice or paying 1 month's salary in lieu of notice before quitting his job. Generally, the burden of proof is on the claimant, whose case will fail if no evidence was adduced. See the case of Nwosu and others versus Okoye and others, reported in 2008, LPELR 2116, Supreme Court at 31, paragraphs D to F, where the Apex Court held, and I quote, the burden of proof is on the party who will fail if the case, in the case where no evidence is given. Although the burden of proof is generally on the plaintiff, it is not invariably so. There are instances in our adjudicative law where the burden of proof shifts to the defendant. It depends on the nature of the proceedings. Furthermore, in employment matters, contract of employment is usually regulated by the terms entered into by the parties, which are usually reduced into writing and displayed in the letter of employment. Parties are bound by these terms and they cannot go outside them. See the case of Layade versus Panapina, reported in 1996, and also the case of Afribank Nigeria versus Osisi Anya, reported in 2000, citations supplied. On the part of the defendant, he stated, contrary to the position of the claimant, that he did not breach the agreement, nor did he resign willingly, but was coerced into doing so. This to him is akin to a constructive dismissal. What then is constructive dismissal? A constructive dismissal is at the disposal of the employer who, in a subtle or overt way, systematically carries out actions that are geared towards frustrating and harassing the employee out of the employment. In the defendant's disposition before the court, he alluded to a lot of actions of the defendant that culminated in frustrating and harassing him out of employment. In the case of Western Excavating versus Sharp, reported in 1978, 1 All England Report 713, Lord Benin, faced with facts of an employee who resigned his employment due to the frustrating attitude of his employer, listed some of the things the employee would need to prove to entitle him to damages against the employer in constructive dismissal as follows. 1, that there was a repudiatory breach on the part of the employer, actual or anticipated, which must be sufficient enough to warrant the resignation of the employee. 2, that the employee elected to accept and treat the contract as having come to an end. 3, that the employee must have resigned in reaction to the breach. 4, that the employee will not delay in accepting that the contract has come to an end, as delaying too long may be inferred that he has waived his right to contest the breach. In the case herein, if all the extenuating circumstances defendant referred to in his dispositions are actually his reasons for resignation, then the claimant will be pushing the court too far by asking for salary in lieu of notice or any release at all, because it will be the one that is indebted to the defendant in damages and not the other way around. Nobody can benefit from the pot of benevolence of the court as a court of justice and equity when, after employing a person as a gatesman, ended up making him a gatesman, messenger, car wash, laundryman, cook, all wrapped in one. This in its very self is slavery and abuse. Also, this court, as a court of justice, will not be moved into granting remedies to an employer whose actions led to the constructive dismissal of the employee. Furthermore, I noticed that the defendant did not even work up to 1 month before resigning his appointment, whereas the claimant is asking for 1 month's salary in lieu of notice, which by its very nature is asking the claimant to source for money elsewhere to make up for the 1 month's salary that never was. In another vein, the period of less than 1 month ought to be a probation period, to which, under the same claim, no notice will be required, or at worst, a week's notice is what will be required. Now, coming back to the issue of working less than 1 month before resigning, in a circumstance where the employee resigns his employment within 1 month of his employment, the presumption is that either the working environment is toxic, or the employee got more than he bargained for, then by forcing his hand to resign. From the facts and evidence before me, in this case, the only conclusion the court can draw is that the defendant, not sooner than he started working, realized that the working atmosphere was not conducive for him. Also, it is also clear that the employer did not help matters, but contributed in systematically pushing the defendant out of the employment. The defendant, in line with the decision of the court in Western Excavating versus Sharp, started in 1978, 1 All England Report 713 above, did not delay in accepting the fact that his employment had come to an end by way of constructive dismissal, hence his resignation within 1 month of presumption. In the light of the above, the case of the claimant lacks merit and semi hereby dismissed as lacking in merit. That's the judgment, and it is entered accordingly.
At the court, please. We thank my Lord for the well-considered judgment.
Thank you very much. So, what actually? Yes. What makes all these things? Yes. Thank you. What of this man here? Where is he? Eh? Okay. It's not printed yet. We will print it and so that they won't come again another day. Or do they want? Would you want to come again another day? Would you wait and have it printed and I read it? Or would you want to come another day? Okay, call the next one.
Between MTN Communications Nigeria and and Private Telecommunications and Communication Senior Staff Association of Nigeria. The other parties are absent.
Okay. Appearances, please.
Odo, my lord,
Yes.
and Andy Achube
Okay.
promptly appeared for the defendant applicant.
Okay. Yes.
May it please the court.
Okay. Yes.
Pardon me, my lord. We would like to confirm if it is 304 that was mentioned.
304. 22.
It is
Yes.
court.
304 22. 22. Yes.
SC Ndudim
Okay.
with Iyano Oluwagbangoshe
Okay.
for the claimants, my lord.
Bangoshe.
My lord, the claimant is represented.
Yes. Okay. Really? Okay.
Yes, my lord. My lord.
By who?
By Oluseun Odubela.
Oluseun
Odubela.
Odubela.
Yes, my lord.
What's the designation?
Advisor, commercial legal litigation, my lord.
Okay. It is for the defendants.
For the claimants, my lord.
Yes, for the claimant. But in the name Esquire, you are for the defendant.
My lord, 304, we are for the claimants.
For the claimant.
MTN, my lord.
Yes. Okay, how about Mr. Andy? Mr. Andy Achube.
My lord, yes.
For the defendant.
My lord, I'm for the applicant. I'm for the defendant applicant as per the motion filed.
I see.
The
all right.
motion dated the 2nd February and 2nd February.
Okay, Mr. Andy, I've taken down your appearance. I cannot just go and you have so many matters before.
Yes,
yes. This is the only one that we have just tried to write out. So I'm going to read it. And because of the nature of this, initially I should have started with the resolution, but I'm going to start from the beginning to the end. Yes, please.
Okay, my lord.
Yes, please. Yeah, you have to have patience. I'm going to read out everything.
Yes, my lord.
As
Yes.
God pleases.
Yes. Now, this is the ruling of this court on an application brought pursuant to the relevant rules of court and under the inherent jurisdiction of this honorable court by the defendant applicant seeking the following. A, an order of court that where there are competing two or several diverse motions before a court filed by the claimant to amend the capacity of the claimant from its non-juristic person to juristic person, and the defendant's notion on jurisdiction challenging the capacity of the claimant, not exhausting internal remedies of subsisting trade disputes before rushing to the court, that are not on irregularity of the procedure. The court is to first hear the motion or motions of the defendant of the jurisdiction. B, an order of court that the defendant's pending motions on for striking out or dismissal of claiming or rejecting summons filed on the 21st day of June 2022 are not on grounds of irregular procedure of the originating summons under the rules of this court, but on the substantive laws of the invalidity of the originating summons of the claimant. C, an order of court that the claimant's motion for amendment is not on irregular procedure of the originating to regularize summons under the rules of court, but on the substantive law of the invalidity of the originating summons of the claimant. D, an order of the court that the claimant's motion for amendment is not on irregular procedure, regularized the originating summons under the rules of the court. And E, an order of the court that there is no subsisting valid originating summons before this court as a live issue to be adjudicated upon by the courts. The grounds upon which this application is brought are as contained on the face of the motion paper. The application is supported by 16 paragraphs affidavit deposed by one Elisha Adamu, designated as a staff of the claimant and a member of the defendant. The defendant applicant in his written form formulated 3 issues for determination, and these are: A, whether or not the claimant's motion for amendment is on procedural irregularity and it affects the claimant as a non-existing person. B, whether or not the claimant's affidavit deposed by counsel in this contentious matter and not usable by this court. C, whether or not in law, the court has jurisdiction to entertain the claimant's motion for amendment filed by a non-existing person, that is a claimant, stated that there is a misnomer of mistake in the name of the claimant. Canvassing arguments on issue number 1. Senate Applicants Council submitted that in the eyes of the law, the claimant's application for amendment is not on a procedural irregularity as it was filed by a non-existing. On the second issue, counsel contended that the fact that the counsel to the claimant deposed to a counter affidavit in a suit with contentious application implies that she has said herself to her client and an offensive the rules of professional conduct for legal practitioners, 2007. Fighting the case of Akinlade versus Akinlade 2017 Nigeria 1754 549. Learned Applicants Council on issue number 3. Are you really hearing what I'm
hearing, my lord.
Because the noise is really terrible.
My lord, I can't hear you. And a participant is not muted, my lord. Any Uche, please. Any Uche is not muted, so we are unable to hear the court.
Mr. What? I didn't hear you, please.
A participant, my lord, any Uche is not muted, so we're unable to hear the court, my lord.
Okay.
They didn't give me.
Any Uche, please mute your mic. Any Uche, we can't hear. Mute your mic, please.
Ms. Uche, can you mute your line so that we see if we can hear what you're saying? That's all right. Now, the Learned Applicants Council on issue number 3 submitted that for an action to be properly constituted so as to vest jurisdiction on the court to adjudicate upon, there must be competent claimants. He cited the case of Ataguba and Co. versus Gura Nigeria Limited, reported in 2005. Citation fully supplied. Only natural, juristic, or artificial persons, such as a body corporate, are competent to sue or be sued. Where this is not the case, the action is liable to be struck out, as it affects the jurisdiction and competence of the court to entertain a matter. The claimant, he said, has no virus to apply for an amendment of his name to a juristic person. He cited the case of Fawehimi versus MBA, reported in 1989, 2 Nigeria Weekly Law Reports, part 109, page 558. Jurisdiction, he said, is the life wire of any litigation, and once raised, it must be dealt with first. A court cannot donate jurisdiction on itself. The error of the claimant seeks to amend is no. Counsel urged the court to grant the application of the defendant. In response to the defendant's application, the respondent filed a reply address. On issue number 1, counsel submitted that what the claimant in this suit seeks is to substitute his proper legal name in place of his name, instead stated in the wrong form, and no new entity is sought to be introduced, but rather the entity which both parties knew from the onset to be the proper entity. Counsel, relying on the case of Alaji Mailafia Trading and Transport Company Limited versus Veritas Insurance Company Limited, reported in 1986, citation supplied, argues that both parties are well known to each other. The defendant is the trade union of the claimant's employees. All documents exhibited as part of the originating summons bears the correct name of the claimant. There was no confusion, and the defendant fought the application for an injunction in this court by presenting facts of his interactions with the claimant in his proper name. The records of the Honorable Court are clear. Again, there is no other company in Nigeria which bears the name MTN Communications Nigeria PLC. The name, even though wrong, could only refer to MTN Nigeria Communication PLC. Therefore, an amendment can be granted to cure such technicality, which will neither vitiate nor nullify the whole proceedings. In the case of Njoku and UA Foods, reported in 1999. Okay, that's what he cited that for emphasis. On whether or not amendments are retrospective, Learned Counsel submitted that it is a basic principle of law that amendments are retrospective and date back to the time of filing. Amendments are applicable to all previous proceedings, and the court has the power to so order. This court has the jurisdiction to grant an amendment where mistakes are made in the name of parties to an action, referring to Ikechukwu and Sons versus Nda, reported in 1967, Nigeria Monthly Law Report, page 368. He urged the court to hold that the claimant applicant is an existing person who has instituted this action in the wrong name, that the error is a misnomer and a mere technicality which will neither vitiate nor nullify the whole proceedings. The learned Silk ordered the court to strike out the issue of jurisdiction raised by the applicant, since it is a live issue, in a separate application before this court and should not be prejudiced here. On issue number 2, the learned counsel to the respondent submits that the true position is that although the court disapproves of the counsel deposing to an affidavit in a contentious case, it does not on its own invalidate the said affidavit. The case relied on by the applicant's counsel has no bearing with the issues at hand and is not applicable to the defendant's arguments. It is misleading in its usage. Leonard Silk urged the court to discountenance the applicant's submissions and dismiss the application. Reacting to the claimant respondent's opposition to his application, the defendant applicant filed a further affidavit and a reply on points of law, wherein the applicant contended that the respondent's reply address is in law fundamentally flawed, incurably defective, incompetent, and terminally fatal to be sustained and used by this court in this application, as it is a flagrant violation and breach of order 17 Rule 1 sub 12 and order 18 Rule 3 sub 5 of the rules of this court. And that it is an elementary piece of principle of law that where a respondent to an application fails to file a counter affidavit to contradict any of the facts deposed in the affidavit in support of the application, the truth of those facts deposed is admitted unchallenged and undisputed and are to be acted upon by the court. He referred to the case of Badejo versus Federal Minister of Education, reported in 1996 at Nigeria Weekly Law Report, part 464, page 15 at 20, paragraphs E to F. Then, upon the careful examination of the processes filed by the parties and the arguments in support of their various positions, the court distills the following issue for determination. And that is, given the circumstances of this suit, is the instant application meritorious and such that ought to be granted? The defendant applicant contends that where a respondent to an application fails to file a counter affidavit to contradict any of the facts deposed in the affidavit in support of the application, the facts deposed in the supporting affidavit would be deemed to have been admitted. It is true that facts admitted need no further proof, and that ordinarily, where there are no depositions to contradict the facts in an affidavit, the facts deposed in the said affidavit would be considered to be uncontroverted. But the latter does not always hold true in all situations. In other words, the presumption that unchallenged and uncontroverted averments are deemed admitted does not hold true in all situations. So where the positions in an affidavit in support of an application are contradictory, or if taken together, are not sufficient to sustain the applicant's prayers, a counter affidavit in challenge of such disposition would manifestly become unnecessary. Thus, there is no rule of law that makes the filing of a counter affidavit to an application a sine qua non in every case. See the case of Ejiofor versus Okeke, reported in 2000, citation supplied. The issues of the purported irregularity referred to in the applicant's supporting affidavit border more on issues of law, which Leonard Silk to the claimant's respondent has responded to by the reply address. Leonard applicant's counsel submission in this regard are hereby discountenanced. I so find and I so hold. The defendant applicant has as its prayer number 1, a request for an order of the court to hear its application on jurisdiction in order of priority in the hearing of consideration of pending applications before a court, contending that where there are competing two or several diverse motions before the court filed by the claimant to amend the capacity of the claimant from its non-juristic person to a juristic person, and the defendant's motion on jurisdiction challenging the capacity of the claimant, not exhausting internal remedies of subsisting trade disputes before rushing to the court that are not on irregularity of the procedure. Court is to first hear the motion or motions on the defendant on jurisdiction. Order 18 Rule 2 of the Instant Rules of this court, 2017, provides a guideline for the consideration of pending multiple applications. It states in Rule 2:1 that where there are multiple motions in a motion before the court may consider taking the motions in order of filing and type, but may hear the motion that regularizes or serves the matter before taking that which may terminate the matter, provided that where there are many defendants in a matter before the court and there is a multiplicity of notice of preliminary objections, either touching on A, the jurisdiction of the court to hear the matter, or B, the competence of the court to hear the matter, or C, application of the statutes of limitation, the court may hear the matter in the order listed in paragraphs A, B, C of this rule. 2, where in a matter before the court, a defendant wishes to dispute the jurisdiction of the court to entertain such a matter, the defendant may, by a motion on notice and an affidavit disclosing the facts in support of the application with a written address, apply to the court to hear and determine the motion. Where an application made in line with the provisions of sub-rule 2 of this rule, the court may take such application together with the claimant's substantive suit. While it is true that the rules of courts are not for fancy, as they are meant to be obeyed and give order to procedures in a judicial process, on the issue of the order for hearing and consideration of multiple pending applications, the interest of justice is paramount. It is clear from the records of the court that the claimant respondent instituted this suit via the originating summons, which is a unique judicial process, largely for the interpretation of laws, documents, that is, non-contentious matters. The claimant has filed an application seeking leave of the court to amend its originating process. The applicant had filed a notice of preliminary objection and an instant application to supposedly challenge the regularity application for amendment. In the case of Matinja versus Military Administrator of Plateau State, reported in 1998, the court held that the order of treating multiple applications that come simultaneously before the trial court is a matter of the discretion of the court to hear application before it. However, the court is guided by the considerations of doing justice and ensure ultimately that the dispute between the parties is decided on its merit. Similarly, in the case of Jaja, reported in 1995, citation supplied, it was held inter alia that priority in dealing with 2 or more applications before the court, though a matter of the court's discretion, the guiding principle is that the interest of justice demands that the application, the determination of which would serve the substantial action, should first be heard, unquote. Notwithstanding the fact that the defendant applicant has a pending notice of preliminary objection challenging the jurisdiction of this court to entertain this suit, and the competence of the suit based on the alleged non-existent claimant, the applicant cannot respectfully lure the court to hear and entertain application on jurisdiction through the back door, as well as hear and entertain his applications over and above all other pending applications without recourse to what in the interest of justice is best for all the parties and the courts. It is true that the law is that where there are multiple pending applications, and where amongst the pending applications an application raises the issue of jurisdiction, the application of jurisdiction should be taken first, as in the case of Fagbola versus KCC IMA, reported in 2006. The same law has also set a guiding principle to guide this court in the exercise of its discretion on the priority to be given to pending applications, which is what the interest of justice demands. Order 18 Rule 2.1 of the rules of this court permits this court, in the exercise of its discretion in entertaining pending multiple applications, to, amongst other things, hear them based on the order of the dates of their filing or their type, or based on the nature of the application, considering application first that seek to regularize or save a matter before those that seek to terminate the matter. In other words, the order of consideration is not one cast in stone. The applicant cannot, with due respect, dictate to the court what order it should follow or adopt in the hearing and considerations of pending applications. If for whatsoever reason, it strongly feels that there are certain irregularities surrounding the claimant response application for amendment, it is well within his right to challenge such irregularities by the procedure set out in Order 5 Rule 2 of the National Industrial Court of Nigeria Civil Procedure Rules 2017. It cannot use the purported application for setting aside an irregularity to re-argue its preliminary objection and address sundry issues not related to the said irregularity or application for amendment. Counsel should know that frivolous applications tend to make the wheel of justice move at a snail's speed and does not make the process of law dynamic in a growing society. See the case of OBSCA versus OBSCA, reported in 2007, citation supplied. I have said more than enough on this regard. It is the considered view of this court that most of the issues raised by the learned counsel to the applicant on the supposed irregularity by the claimant's application for amendment are such that can be conveniently taken alongside the issues raised in consideration of the application. Learned applicants' counsel cannot respectfully file 2 separate preliminary objections with tact. The issues of jurisdiction has been raised by the applicant in his notice of preliminary objection earlier filed before this court. If there are other jurisdictional issues, the applicant's counsel can as well raise them appropriately so as to avoid clogging the court's docket and making its processes appear to constitute an abuse of court's process. It is in the light of the above that issues bordering on jurisdiction and the jurisdictional competence or otherwise of the claimant's application for amendment which is still pending before the court, would not be considered by the court now. It will be tidier and circumspect, please, in the considered view of this court, to take and consider all pending applications in a swoop, so as to avoid the pitfall of entertaining and delving into the merits and or competence or otherwise of pending applications. The applicant's prayers with respect to these issues are accordingly discountenanced. I so find and I so hold. The applicant's counsel has, however, raised a preliminary issue surrounding the purported irregularity of the claimant's counter-claimant affidavit to its notice of preliminary objection, deposed to by one counsel representing the claimant. The applicant contended that the said counter affidavit is defective as it contravenes the provision of Rule 20 sub 4 of the Legal Practitioner Rules of Professional Conduct 2007. The law, as rightly canvassed by the learned Silk, is that an affidavit deposed to by counsel in a case in which he appears will not be declared inadmissible in evidence under any provisions of the Evidence Act or any other legislation validly enforced in Nigeria, since both competence to give evidence or depose to an affidavit, as well as admissibility of such evidence is proceedings before the court of law, are governed and regulated by the provisions of the Evidence Act. Referring to Akinlade versus INEC, reported in 2020, and also owners of the MT Marigold versus NNPC, reported in 2022. Citation supplied. Although the rules do not render evidence given or deposed to by a legal practitioner in a client's case in which he appears as counsel inadmissible in evidence in the proceedings of court, they render such legal practitioner liable for unprofessional conduct in contravention of the rules of professional conduct for legal practitioners and other appropriate penalties to be imposed by the court before which the contravention or breach occurs. In the case of Nwite versus PDP, reported in 2023, this shows up. This court is obligated to evaluate same as evidence before the court. Besides, the applicant has not shown what injustice or harm counsel deposing to the said affidavit has occasioned it. Also, the determination of whether or not a matter is contentious is one that is for the court to decide, and not counsel who has impressed the position on same to the court. The courts have since moved on from undue reliance to technicality. The courts have since moved on from undue reliance on technicalities to doing substantial justice. Wherefore, all claims must be adequately investigated and determined on its merit. See SPDCN versus Equems, reported in 2023. The learned counsel to the applicant's submission with respect to the supposed irregularity or defectiveness to the claimant's counter affidavit in opposition to its notice of preliminary objection is accordingly discountenanced in the interest of justice and fair hearing, and I so find and so hold. From the foregoing, it is a considered view of this honorable court that in addition to the fact that it will be tidier and prudent to take all pending applications in one fell swoop and rule on them one way or the other, the interest of justice and fair hearing demands that the court does not delve into consideration of the competence or otherwise of pending applications without first hearing the entertaining them. Consequent upon this, the court finds no merit in this instant application. It is accordingly dismissed. I so find and I so hold. And that is a report.
As the court pleases.
Yes.
Lord, we are grateful for the well-considered ruling.
Thank you very much.
And we look forward to a date to move the application to amend, my Lord.
Yes, that's what we are. My registrar is looking at our diary. You know this case. In December or next year. Council.
My Lord, if you can get an October date.
You know, the vacation stretches to the end of September. So
Yes,
we
my Lord.
start off in October. And by then, this is a 2022 case. The other older ones are already lined up. So let's go to November. It's just because of the nature of this case that we are taking November. Otherwise, should have gone to January. But the sooner we conclude with you parties.
Yes, my Lord. The application is a simple application, my Lord.
Okay.
Yes, my Lord. It's for leave to amend.
When?
The application is okay. I can't hear. I can't hear you.
Yes, because when the court has ruled that we take all the other ones in one fell swoop. There is no how the court will take cases that have one or two preliminary objections and we will take all of them in one fell swoop. So yes, I'm thinking of a date for mention, then we take a date when we will now hear all of them.
Okay. November 1, my Lord.
All sense. No, I think 1 and 2 are very important. Is there any date? January. No, that's what I'm saying. We mention it, then we take a clear date in. Ndodeme Squire, are you there?
Yes, my Lord.
How about 16th November? Mr. Andy, I don't think.
Okay.
16th of November, or we go to December. But November will be better because there are so many things to consider in this case.
16th is fine, my lord.
Okay. Okay. Given the fact that the entire suits in this entire cases in this concerning this matter will be heard in one fell swoop. This matter is now adjourned to the 16th of November 2023 for mention. On that date, we take a very clear date, if possible, the only date that will be reserved for this case. So we come back on 16/11/23 for mention.
As the court pleases.
Okay.
Very well, my lord.
Okay.
My lord, pardon me, my lord.
I'm hearing you.
Yes, my lord. Considering that the court has hinted that the ruling for the other matters are not ready.
No, not ready. No, I'm saying that this you have been here in this matter now.
Yes, my lord.
Yes, and some of them we have multiple preliminary objections. We can't take them one after the other. So we have in this ruling ruled on the very preliminary issue, that is of the application for amendments. We say there is no how we can talk of jurisdiction, all those things, without knowing who are before us. So we have taken the application on amendments. Then in the other next things, the next thing to do is to now hear all these things. You know, there are so many preliminary objections. There are so many counter claims and counter claims and everything. No, on that date, that is when we will now bring it to the fore and know how we are going to hear it, because we are going to hear all of them together because they are all connected. We cannot hear them differently. So on the 16th of November, when we come, we will now, the court must have, the court will tell you how it will be done. All the preliminary objections that are talking of the same thing, we hear them together. All the other things that are talking of the same thing, we hear them together. So that is it. It is not the ruling on other ones. No, not the ruling on other ones, because they are, you were here now, you know this case. So it is on that date. Even if it is a ruling, you will hear it. Whatever it is, you will hear it, but it is adjourned on that date for mention. It is on that date that we will know what to do. I don't know if you understand. Yes. Okay. All right. So, Mary, what are you saying?
Hello, good afternoon. Fine. Huh? I think I'm sorry. I've been calling you since 2-3 days and you're not picking. I don't know. I was wondering what the. I think. Okay, 2 days. What up today? Why your voice there like this? Okay, sorry. So you are weak now. Okay. I was wondering why you're not picking my call again. You are busy. Okay. I'm fine. I don't have to take. I just call you back to acknowledge your call. So I was thinking, when I finish, so I call you back. Huh? All right. Huh? I should start what? Okay, the one in Port Harcourt. Okay, all right. So I will call you back so I can try.
Okay. Council, sorry. This last, okay. My name was Ndudem Esquire.
Yes, my lord.
Okay, you're still here.
Yes, my lord.
Of course, you're not in the same place with the other side. Because the court has discovered that one of the remaining rulings is it relates to you and the other side. There's another ruling on it's not just the one that was read. There's
Yes,
another,
my lord.
yes.
Yes, there's 5 other system matters that are not 4 others that are not related to 304. In 304, MTN is the claimants.
Yes.
Yes, and the other 4 were consolidated as a separate matter. That is 368, 369, 370, and 425. They are system matters, my lord.
Yes. So I don't know how to. Let me call Mr. Andy. Mr. Andy, please, are you still here? Or anybody who is here on his behalf?
The counsel on the other side is here, but he's muted.
Okay. He's muted.
Hello, my lord.
Yes, Mr. Andy.
Yes, my lord.
I'm very glad. I'm very glad that you're still here.
Yes,
because
my lord.
when I thought I had finished, I now found out that this ruling also relates to both of you.
Yeah, my lord.
So I'm glad we have not gone off. Yes.
Yes,
So,
my lord.
but I'm going to do a very, very passionate plea to both of you about this, because
Yes, my lord.
it is very, very voluminous, and I cannot finish it because there are some other people waiting for me here. And I want to start
Yes, my lord.
on the resolution, because these are
Yes,
those
my lord.
matters that were consolidated. Yes.
Yes,
So,
sir.
okay. What's your name? Yes, Miss Ndudem Esquire. Are
Yes,
you
my lord.
also in agreement? I want to start with the resolution.
As the court pleases, my lord.
Very well. Good.
Okay.
Yes.
Pardon me, my lord. The parties' appearances are different. We're not the claimants. in this
Yes.
matter.
Yes. Okay. Bring this. Bring. Oh, you should. Please call up the matter. Yes.
We can't hear the registrar.
Call up the matter.
Case number NICN/LA/368/2022 between Private Telecommunications and Communications Senior Staff Association of Nigeria and 1, MTN Group Nigerian PLC. 2, Raphael Mupita. Ralph Mupita. 3, MTN Nigerian Communication PLC. 4, Carl Toriola, MTN Nigerian Communications PLC. And the parties are absent.
Okay.
Third defendant is represented.
Okay. Okay.
Represented by Oluseun Odubela.
Okay. Okay. He said is what's your
Advisor, my lord.
Advice.
Advisor, commercial legal litigation.
All right. Appearances, please.
Before appearances, I wish to still remind the court that this is a consolidated suit.
Yes.
Consolidating 4 suits, as my learned colleague said, so
Yes.
that there will be no need of calling another one, because
Yes.
one ruling applies to all.
Yes. Yes.
Yes, my lord. So just one ruling, my lord.
Yes.
With due respect, my lord, Andy Achubwe
Okay.
humbly appears for the claimant/applicant.
Okay.
Well, I sincerely apologize for the absence of the claimant representative.
No, that's
Not a blame, my lord.
Yes. Yes.
May it please the courts.
Yes.
S.C. Ndudim with A.O. Akinyemi. Our humble appearance is for the defendants, all defendants.
Okay. So I'm going to start with the resolution. Upon a careful perusal of the processes filed by parties and the arguments adopted in support of their respective positions, the following issues for determination are distilled. 1, whether the claimant's application is competent before this honorable court. 2, whether the defendant who did not file a memorandum of appearance ought to be heard on the process filed in this court. The learned silk contends that certain paragraphs of the claimant's supporting affidavit offend the provision of the Evidence Act on affidavits, as they contain arguments and conclusions contrary to Section 115, Sub 2 of the Evidence Act of 2011. The law is settled that an affidavit used in court shall only contain statement of facts and circumstances derived from the personal knowledge of the deponent or from information which he believes to be true, and shall not contain extraneous matters by way of objection or prayer or legal argument or conclusion. The test for determining any particular extraneous matter is to examine each of the paragraphs deposed to in the affidavit to ascertain whether it is fit, only as a submission which counsel ought to urge the court. If it is, then it is likely to be either an objection or legal argument which ought to be pressed in counsel's written address to the court. Or it may be conclusion upon an issue which ought to be left at the discretion of the court, either to make a finding or to reach a decision through its process of reasoning. See the case of Ishaya Bami versus the states.
Not talking. Not hearing them, yes.
Can't hear the court anymore.
Even myself, I'm not hearing the court right from time. Not hearing the court.
So,
good.
Are you hearing me now?
Yes, my lord, we can hear you now.
Okay.
Now.
Okay. The test for determining any particular extraneous matter is to examine each of the paragraphs deposed in the affidavit to ascertain whether it is fit only as a submission which counsel ought to urge the court. If it is, then it is likely to be either an objection or legal argument which ought to be
Run again.
The court is muted.
Are you hearing me now?
We're hearing you now.
Yes, my lord.
Okay. So the court finds that paragraphs 4, 5, 6, 7, 13, and 14 of the claimant applicant supporting affidavit falls into the category of objection or legal arguments which learned claimant's counsel ought to press in his written address and conclusions. These paragraphs contain extraneous matters that are liable to be struck out and are accordingly struck out for offending sections 1152 of the Evidence Act 20. The learned counsel brought this application, challenging the right of the appearance of the defendants as well as their right to file their processes out of time. His grumble is that having failed to file the memorandum of appearance within the specified period set out by the rules of the court, such irregularity could not be cured. Order 9, Rule 1 says that every person served with an originating process shall, within the time stipulated herein, or if no time is stipulated, shall within 14 days of the service of the originating process file their memorandum of appearance in the registry of the court. 2, the memorandum of appearance shall be signed by the party served or by the counsel representing the party, which shall contain full and sufficient address for service. The electronic mailing address or addresses and telephone number. Are you hearing me? 1, where 2 or more defendants in the same action appear by the same counsel, The memorandum of appearance shall include the names of all the defendants so appearing. Leonard Silk, on the other hand, is contending that the proper way to have raised his concerns is to have filed a counter affidavit and a written address in respect of the said cases. Hence, the approach adopted by the claimant applicant is unknown to law. He quoted Order 18 Rule 2.5 as, where a respondent served with a motion or notice intends to oppose the application, he shall do so in line with the provisions of Order 17 Rule 1, Sub Rules 10 and 11, and the matter may be handled in line with the provisions of Sub Rules 12, 13, and 14 of Order 17 Rule 1. Now, the question to be asked at this point is whether the claimant's application is a response to the applications filed by the respondents. Upon a careful examination of the claimant's application, one can infer that the claimant did not set out to object to the notice of preliminary objection and motion on notice on its merit. His application seeks to set aside for irregularity the memorandum of appearance, notices of preliminary objection with affidavits and written addresses, counter affidavits filed 2nd of February 2023 by the first defendant and on 20th December 2022 for extension of time and all associated court processes filed on the 10th day of February 2023 in dispute by the first, second, and third defendants out of time without obtaining leave of court. This is the considered view of the Honorable Court. And in that view is in line with provisions of Order 5 Rule 2 and 3 of the NICN Civil Procedure Rules 2017, reproduced below. That is to say, an application to set aside for irregularity, any steps taken in the course of any proceedings may be allowed where it is made within a reasonable time and before the party applying has made any fresh step after becoming aware of the irregularity. 2, an application under this rule may be made by summons or motion on the grounds of objection and shall be stated in the summons or notice of motion. However, for the court to allow such application, it ought to have been brought before the party applying before the party applying has taken any fresh step after becoming aware of the irregularity. This perhaps may be the reason why the claimant has decided to bring this application rather than file its counter affidavit as anticipated by the respondent. In line with the above rules of court, I am of the considered view that claimant's application is rightly before the court. Therefore, Leonard Silk's argument regarding the form of claimant's application is hereby discountenanced, and the court so holds. The court will now consider the said application on its merit. On issue number 2, I have read the arguments canvassed by both parties as to the effect of failure to file a memorandum of appearance in a suit. Learned counsel for the claimant applicant has argued that the defendant's respondents ought not be heard by this honorable court upon their non-compliance with the rules of this honorable court. On the other hand, Leonard Silk on the defendant's behalf has opined that failure to file memorandum of appearance as in the case in view should be treated as a mere irregularity. Entering of an appearance is a formal step taken by a defendant an action after he has been served with the writ of summons. Its object is to intimate the plaintiff that the defendant intends to contest his claim. See the case of Adego Kemotos Limited versus Adesonia and others, reported in 1989, LPELR 94, it's a Supreme Court case. In the case of Inajoku and others versus Adeleke and others reported in 2010, citation supplied, the Supreme Court held that a defendant shall, before he is heard, entered appearance. If he fails to do so, he's not entitled to be heard by the court. It is strict law that the memorandum of appearance is simply to indicate that the suit will be contested. And where a party has appeared in person or through counsel, the spirit and purpose of the rule is met, and it is indication that the suit will be contested. Therefore, non-filing of the memorandum of appearance in this circumstance will not vitiate the proceedings. See the case of Igwe Linus Nwobodo versus M.O. Nyam and associates. It was reported in 2014. Citation supplied. That means that any irregularity which derives from a breach of rule of practice and procedure of an order of court made thereon does not render the proceedings a nullity, but a mere irregularity. The court may readily exercise its discretion and extend the time to regularize the proceeding. See the case of NISA and Team Associates versus NNPC, reported in 1991, citation supplied. Similarly, in the case of Dogo versus Mbahi, reported in 2018, citation supplied, it was held that the filing of a memorandum of appearance has nothing to do with the merits of the case, and an order which allows for late appearance by paying default fee portrays that non-filing of memorandum of appearance before filing a statement of defense does not go to the root of the case. It does not make the process void. Order 9, Rule 4 of the rules of this honorable court, reproduced below, falls within the category of orders referred to above. That is to say, where the defendant fails to file a defense of memorandum of appearance or any other process after being in default, such defendant or respondent shall pay further penalty as stipulated in Order 57, Rule 5 of these rules, unquote. Moreover, Order 5, Rule 1 of the rules empowers this court to treat non-compliance with the rules as a mere irregularity and give any direction as it thinks fit. This is based on the interests of justice and good sense. The irregularity complained of by the claimant is such that can be regularized, and the court can suo motu direct a defendant who inadvertently failed to enter appearance before taking steps to defend the suit to regularize his position by entering an appearance, however be it late. The court, in the interest of justice and to ensure the sanctity of fair hearing, must stretch to pull the defendant out of the irregularity ditch by directing the defendant to so enter an appearance. See the case of Dogo versus Mbahi Supra. When, after the directive to enter an appearance, the defendant persists in his act of failure to enter an appearance, then the court will not hear him in the proceedings, and such a suit will be treated as undefended, and the plaintiff may proceed to ask for judgment to be entered in his favor, or for the case to be set down for hearing. See the case of British American Insurance Company Limited versus Edema Silo, reported in 1993, and also the case of Ita versus Inyong, reported in 1994, citation supplied. In the case at hand, the defendants have taken steps to show their readiness to defend the suit by filing the memorandum of appearance, notices of preliminary objections with affidavits and written addresses. Counter affidavit filed on the 7th February 2023 by the first defendant, and on 20th December 2022 by the second and third defendants. Motion on notice or applications for extension of time and all associated court processes filed on 10th of February 2023, praying the court for an order granting leave of the court to file same out of time. It is within the discretion of the court to grant the prayers. The claimant's arguments in this regard are disregarded in favor of the defendant, and I so hold. On the question of the competence of the instruments referring to the trade dispute, referring the trade dispute to Industrial Arbitration Panel and the jurisdiction of the Industrial Arbitration Panel, it is the prerogative of a court, while dealing with an interlocutory application, not to delve into serious questions of law, which demands detailed arguments and serious considerations, and therefore the courts do not go into the facts and resolution of which might end up in the determination of the original suit. See the case of Okwara and others versus Julius Berger Nigeria Limited PLC, reported in 2019. And also, okay, yes. On the question of whether or not the first and third defendants are parties to this suit, as well as the validity of the reasons given by the defendant in his motion on notice to extend time, determination, and these issues on the basis of the instant application, while not out of order, may have the effect of shorting the claimant's rights to respond to these issues, which have also been raised in some other applications before the court filed by the defendants, which are still pending. I am of the considered view that it will be tidier to take these applications, give room to the claimant to properly respond to the issues therein, and then the court reaches a decision one way or the other with respect to same. I hold this view in the light of the fact that the instant application majorly targets and supposedly irregularity of the defendant's appearance and processes before the court. Given that this is the fulcrum of the said application, it presupposes that if the court upholds the instant application, these issues, as well as others raised and canvassed by Leonard Silk, would have to be discountenanced by the court for the failure to cure the irregularity that surrounds their competence. The claimant applicant, with due respect, cannot contend that something is incompetent for failure to satisfy a condition precedent, and whether on excuse of erring on the side of caution or not, proceed to address issues raised and canvassed in the purported incompetent processes. When these applications have not been moved or heard, it would obviously be premature to rule on them at this stage. Having found that the defendants have taken steps to set in motion machinery to cure the said irregularity, the court cannot preempt the action of any of the parties. Its duty is to give each party equal opportunities to present its case as best it knows how. In other words, consideration of all other issues bordering on the jurisdiction of the court, whether or not certain parties are proper or unnecessary parties to the suit, whether or not the suit is a trade dispute, would be akin to giving the process Leonard Silk has contended constitutes an abuse of court process. I think the proper thing to do is to permit the claimant, if it elects to respond to the manner set out by the rules of the practice of the defendant's application, hear the application that traces these issues, and then the court can rule. Issues 2 is resolved against the claimant applicant. This court finds and holds that the instant application filed by the claimant applicant lacks merit, and same is struck out. And that is the ruling of the court on this issue. And ruling is hereby entered accordingly.
As the court pleases.
Yes.
Court pleases.
We appreciate the court, my lord, for this considered ruling.
Thank you.
My lord, if you may ask for a date to come back for the consolidated matters, my lord.
Okay. Can we still take January now? Yes, let's think of a date in January.
My lord, we humbly crave the court's indulgence for first week of December, my lord, if the court can accommodate us.
Okay, that's not the same thing as January.
Yes, my lord.
Oh, Jesus. So, Mr. Andy, are you still there?
I'm there, my lord. Just sure, I thought we could accommodate the same date for the 304, which we are coming to make argument on the motion for amendment, whether it should be allowed or not. Which is so that I will take them. It's normally issue of adopting now. I don't think there's much apart from elucidation that doesn't take time. We can take the same date, subject to cost covenant, or even within the same month. So that we do away with all these cases. The adoption, we can be given another date within the month. December is very far. December, November, we can be given to another date in November, my lord. That's my humble application. Another date in November. Because the other one is 16th
we are thinking
November.
of a date when the list of matters are not long, because but I know you know what I mean. Whenever your matter comes up, you are strongly on your side, and the learned silk is there. So before you conclude, it takes 1 or 2 hours. So I was thinking of a date when the list of cases is quite short. We're even thinking of giving you two one date and closing that date, because we know that you have a lot to say and the learned silk has a lot to say. So that's why we are not just taking any date. We want to when both of you.
Yeah, the 304 is for mention now on 16th. My lord, the court said it's for mention.
It was for mention about all this consolidation. But when the court picked up the next ruling, I found out that the issue of consolidation has been is the next one. That is why I called you back. Yes.
The consolidation.
Yes, this is this one we read is amongst the consolidated matters, whereby somebody was said not to have done the proper. Yes. Okay.
So
yes.
Because with the ruling now, the preliminary objections raised, the 15 of them are going to be heard. Whichever way, either in a consolidated form, I don't know how the court is going to do it. Because there are 15 preliminary objections.
That is
which
why
we have
wants a lot on there to you, and that will be in January.
Okay, let's take December. Let's take let's take the 1st December. Malene colleague suggested is first week. Sorry, please. First week, any date in first week of December, so that we don't lose track of the matters. So any date first week of December, my lord, we will appreciate, my lord. Any date first week of, as suggested by Malene colleague. That's Barrister Minat.
Okay.
That's my lord.
What of this? Okay, we don't know. Captain Opera. These people. What is this? Okay. Honorable.
My lord.
I don't know whether I don't like calling you Andy Esquire.
I know, my lord.
I want to have something to eat. Honorable. So
yes, my lord.
Can you Miss Ndodem look at December 13th? Is that it? Look at December 13th. If it's not on that date, then we are definitely going to January. December 13th.
It's okay by me, my lord.
We are joining it on December 13th. We cross out the dates.
13th is Thursday. I think it's Wednesday. It's okay, my lord.
Yes. What day? It's Wednesday, yes.
Yes, my lord, 13th.
Okay. How about
We're
you?
good.
Okay.
Yes, my lord, it's convenient.
Okay.
All right.
Case adjourned to 13, 12, 23, 4. This is when we hear everything for all the preliminary objections. They're all applications.
Yes.
Yes, for hearing.
All right, my lord.
My lord, we have a simple, small prayer to ask, my lord.
Okay.
That on the 13th, when we come, counsel to the claimant would have responded if he intends to respond to everything that we have filed. And we just regularize our processes and just move, so we don't come and move our application to regularize and then we take another date for hearing. So I will humbly ask the court to direct that he does so if he intends to.
No, he's a very senior lawyer. He will do so without prompting. He should do that.
As the court pleases, we are most grateful.
My lord, no problem. Regularizing is filing out of time because of the ruling. Otherwise, they would have not filed. But as the court rightly observed, so we regularize and adopt my lord. We're not arguing anything. It's to adopt our addresses. So we can do them together. The issue of motion for extension of time, they are raising their own. Then we regularize, my lord. Regularize and adopt our addresses instead of coming again to come and argue. We have nothing to argue now.
Okay.
So what I'm going to file is in response to their notice of preliminary objection, and most of them are issues of law. So we can take them. We take the regularizing, that is motion for extension of time. Then we adopt our written address. That's all. We take that for ruling. There's no need of coming to Lagos every time.
Is that all right?
Yes, my lord.
Is that all right for you?
That is all right, my lord. Thank you, my lord.
Okay.
All right. We're grateful, my lord. Thank you.
Therefore, the matter is now adjourned to the 13th day of December 2023 for hearing of all the outstanding applications.
As God pleases. In the consolidated suits.
As the court pleases.
Yes, of course. They've been consolidated. We can't separate them again in the consolidated suits.
Yes, my lord.
Thank you.
Yes, my lord.
Okay.
Okay. Well done. Well done. Off.
when you walk out from here without anything. Now, this thing refused to, it just typed out the resolution, which I've been reading out to others. It didn't type out what first, second, third, and all the other people did. But then that resolution does not involve your, because I remember the first and fourth defendant applicants' written address in support of this application. The learned counsel to the applicants formulated a sole issue for determination whether, having regard to the circumstances of this case, the claimant complied with section 4.1 Bofia and fulfilled the mandatory requirement of section 419 of KAMA. That was what you said. But in the one that was typed out only had to do about the preliminary objection without touching this your own. But it will come out before you get this. We now get everything you said and how the court reacted to it and put it together before giving it to you. But right now, as you are sitting down now, the court, what just came out here is this. So please don't let it bother you. You will get everything on this because it's already written out. Yes. So this one, I've been seeking permission to start from the what the courts, the ruling of the court. But now this one is forcing me and forcing you also to hear only what the court wrote out. So you can sit down, let me read it out. So call it up, by the way. Do you have it? Sky Bank Limited and two others. Okay. Yes, because they're not here. Okay.
Case number NICN/LA/409/2016 between 1 Akinojo Joseph Akinyemi and 14 others, and 1 Sky Bank Limited, 2 Association of Senior Staff of Banks, Insurance and Financial Institutions. My parties are absent.
Okay. Also, Polaris Bank.
My lord, may it please your lordship?
Yes.
My name is Dr. Susan Agu.
Okay.
I respectfully appear for Polaris Bank, the third defendant in this matter.
Okay.
May you please your name?
Yes. Yes.
My name is Ayomide Ayileka. I announce my appearance for the first and the fourth defendant.
E.A. Kura.
Okay.
My appearance is for all the claimants.
Okay.
Case number NICN/LA/409/2016 between Akinojo Joseph Akinyemi and 14 others, and 1 Sky Bank Limited, 2 Association of Senior Staffs of Banks, Insurance and Financial Institution, 3 Polaris Bank, 5 Nigerian Deposit Insurance Corporation. My parties are absent.
Okay. But okay. Then I've taken the appearances. Okay. 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 So it means the third defendant is not represented.
My lord, the third defendant is Polaris Bank.
Oh, no, that's the fourth.
No, that's the third, my lord.
Huh?
That's the third defendant. Polaris Bank is the third defendant. The fourth defendant is NDIC.
Okay, NDIC.
Yes, my lord.
Yes, my
Okay,
lord.
so this is the fourth. This is the third. Then Association of Senior Staff, ACBFI, is 2.
It's 2, yes, my lord.
Skybank is 1. What of? Okay, this is particular. Okay. Very well. Okay, council. I don't know how you're going to take this, but in this particular one, you know, because of what caused this all these rulings to accumulate so much. Because of it, there are so many judgments and rulings which we have now been taking virtually. But in this particular one, I am so sorry to say this. The ruling is all right, but after the printing, we found out that the printing, just the only complete one is the decision of the court, without saying all the things that happened before this decision. So what I want to say is this: I'm going to read out this brief decision of the court, but before we give you the signed copy, we must have printed out the ones that are not here. We print it out and it will be a full ruling, because this ruling, just beginning and the end, is what, you know, they were able to print out before our machine went bad. So I'm going to read out the other the decision of the court. I hope it is all right with all of us.
It's fine, my lord. It's fine.
Okay.
It's
All
okay.
right. Even though I must say that for Mr. Raphael, because of, this thing doesn't mention your position, but it will come out in the full ruling. Yes, now it started with, given the, I don't know whether to read the beginning. It's not complete. Given the circumstances of today's hearing, the court shall read an abridged version of the court's ruling, and counsel and parties shall have access to the complete version. I've just added this one now. Now, having gone through the notice of preliminary objection by the applicants and their submissions, as well as the response of the claimant applicants in opposition to the application, this court has distilled the sole issue for determination, and that is to say, whether, given the circumstances, there is merit in the notice of preliminary objection. The gravamen of this application is that this action herein runs foul of the relevant sections of Bofia and Kama, and as such, the court lacks jurisdiction to entertain this matter and should dismiss the suit. This is the position of the first defendant applicant, Skybank Limited, and the fourth defendant applicant, Nigerian Deposit Insurance Corporation. The law is right that jurisdiction is a serious issue. However, no matter how serious it is made to look, it is never the law, and it will not be any time issue of jurisdiction is raised, the court must throw in the towel and decline jurisdiction. See the case of Attorney General of the Federation versus Guardian Newspaper Limited, reported in 1999, 9 Nigeria Weekly Law Report, part 618, page 187. Rather, whenever the issue of jurisdiction is raised, it is an invitation for the court to look at the circumstances warranting the issue, and from the facts and the law, determine if the court has jurisdiction or not. Secondly, if the challenge on jurisdiction is grounded on the improper parties being brought before the court, the proper thing for the court to do is to strike out the names of the parties not properly brought before the court and proceed on the ones that are properly brought before the court. rather than striking out the whole suit. In this preliminary objection, and in all fairness to the applicants, the ground for this preliminary objection have either been overtaken by events or are futuristic in nature. For the benefit of doubt, the section of both fear and karma cited by the applicants put forward the question of whether the now moribund Sky Bank is still undergoing the process of receivership, or it has been sold to a new entity known as Polaris Bank. It throws up the question of whether the claimants herein are seeking reliefs, which became due after the takeover of the first defendant, or after the takeover of the first defendant. It also throws, please stop talking, stop. It also throws open the question of whether in mergers or in acquisition, the assets and liabilities of the former do not pass to the new owner. Furthermore, I noticed that in determining this suit of preliminary objection, the court may be delving into the merits of the case, whereas the law is right that the court should not delve into deciding the substantive suit by way of an interlocutory application. The law forbids the court from, in the course of consideration of an interlocutory application, to delve into the consideration of issues that border on the substance of the suit. For the reason given above, the court finds no merit in this notice of preliminary objection, and same is hereby dismissed. I make no as to cost. The parties are to bear their respective costs, and ruling is entered accordingly.
As the court pleases.
Yes, but remember that I said the courts and parties shall have access to the complete version of this ruling by the time we give them to you. Thank you.
We thank your lordship.
Your lordship.
Thank you. Thank you. Please, somebody come and give me this. I'm so sorry. It will, because it's not complete. It will be for, shall we say for mention? So that you must have read the entire ruling.
As the court pleases.
As the court pleases.
Okay. So it can be a very far date. It can be January. So give me a date before the end of the year. How do you stand on the 16th of November for mention?
16th of November. 16th is convenient, sir.
Okay, for you.
Yes.
Okay, how about you, Susan?
It's convenient, my lord.
Okay.
It's convenient. My lord.
Okay.
Yes, my lord, it's coming.
Okay, 16th of November 20.
For mention, sir.
Yes, by then you must have gotten the full ruling. Then you consider your actions. So the matter is adjourned to the 16th day of November 2023 for ruling.
For mention.
Sorry.
For mention, right?
For mention. I think my brain is going. So,
God pleases.
so that is it.
As the court pleases.
Yes.
But we wish your lordship a happy holiday.
Hey, thank you very much. I wish that on myself too. I wish you the same while you're flying out.
I thank your lordship.
Yes, fly to a warm place, please.
So I will.
Yes.
I will. Thank you, lordship.
Thank you very much. Okay.
Yes, yes, my lord. Thank you, sir.